of Appeals, Division 1 is now in session.
Be seated. Now is the time set for oral argument in cause number 1CACV 150482, Tempe versus Tempe Flour Mill. For your information, these proceedings are being both audio and video recorded, so barring any unforeseen technical problems, you can enjoy critiquing yourself, I guess, in a few weeks on YouTube. Counsel each side, as I'm sure you are well aware, will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can try and avoid taking up all your time. However, ultimately, your reserving of rebuttal time is up to you. We have reviewed the briefs. We have conferenced the case this morning, so we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in addressing this court this morning. Counsel, when you come to the podium, I would ask that you state your name and who you represent. And with that, you may begin.
Thank you, Your Honor. Jeffrey Gross, Barry Riddell, representing the appellant Tempe Flour Mill. This is an appeal from the trial court's decision that the agreement between Tempe Flour and the city of Tempe expired as a matter of law automatically on April 2nd, 2008. We're also appealing the trial court's decision that Tempe Flour's ability to challenge the city's actions expired because of the statute of limitations, also as a matter of law. I'd like to start off by beginning with the interpretation issues on the development agreement, because that's where the substance of this case is. And any interpretation has to start off with Section 6.1b of the development agreement, the first sentence of which provides that escrow will close, escrow on the sale of the property between the city of Tempe and Tempe Flour Mill will close upon the issuance of a building permit for the first phase of development. The second sentence starts out with, notwithstanding the foregoing, in no event shall closing occur later than 18 months after execution of the development agreement.
Counsel, that is so central to the issues in this case.
Yes, it is.
Fair to say you've just given us two sentences. The first sentence says something. The second sentence says, okay, notwithstanding the first,
right,
even given the first, that the escrow is to close no later than April 2nd, 2008.
Correct.
That's a drop-dead date, right?
No, it isn't, Your Honor. That's a drop-dead. Well, it depends, I guess, who it's a drop-dead date for. Okay. Our position is that notwithstanding, that phrase, notwithstanding the foregoing, means no matter what happens with the issuance of the building permit, whether the building permit is issued or not, the city's obligated to close no later than 18 months after execution.
And
so
everyone agrees that's April 2nd, 2008.
Everyone agrees that that expiration date is April 2nd, 2008.
And so what happens on April 2nd, 2008 if number one hasn't happened, you get to April 2nd, 2008, you haven't closed escrow. I said drop dead date. I think we understand that kind of in the parlance of the practice a bit. What does that mean? How do we interpret that?
That means the city's obligated to close. Because notwithstanding the fact that building permits weren't issued, 18 months has elapsed and it's going to close. That second sentence means forget what happens with the building permits. This transaction is going to close. It must close within 18 months from execution.
And the fact that it did not, does your alleged injury, your alleged claim accrue on that day?
No, Your Honor, it did not, and that gets into the statute of limitations issue. First of all, this goes to, I think, the interpretation issue and the statute of limitations issue. even the city didn't treat this as an automatic termination provision back in 2008. In 2008 into 2009, the city continued processing plans. The city had an email dated April 22nd, 2008 that said, we expect to close sometime during the June, July, August time frame of 2008. And here are some other issues we'd like to talk about. Do you have any others?
But the DDA gave you the day the closing didn't happen. So at that point, aren't you on notice? Gee, I think we have a problem here because we were supposed to close and we didn't.
No, because everybody treated the inability to close under the unique circumstances of this case as a reason for carrying that forward.
Was it Tempe's duty under the contract then to see that that closed by April 2nd of 2008? Is that what you're saying?
Yes.
Okay, so the burden was on Tempe, not on the flour mills, not on TFM.
Flour mill, yes. Tempe flour mill.
Okay. You're saying that the way that one provision, and you said it was the most important, you have to start with it. No kidding. We've spent your time so far on 6.1.b. You're saying that the burden was not on TFM to close escrow by that date. The burden was on the town of Tempe or the city of Tempe. I've been around here too long. Mm-hmm. It's a city now. The city of Tempe to see that escrow closing was met.
Well, it's a bilateral agreement, but yes, at the end of the day, the city was obligated to close on April 2nd, 2008, as it turned out.
Well, and forgive me if I'm taking this out of order, but they didn't close when everyone had agreed on. You may have waived, the closing because of the circumstances, but your cause of action for making sure that occurred at whatever time began on April 2nd, correct?
I disagree, Your Honor. And that's
and why?
Because of the terms of the development agreement that also required the city to provide notice. The city was positioned later in 2011 was that it automatically terminated. So somebody was obligated to provide notice. That didn't occur because the parties, and I think it's undisputed in this case, the parties agreed to weather out the Great Recession of 2008 through 2011 and cooperate and not default each other. But there were default provisions that did not happen. There's a mediation provision that did not occur.
And the question I've had in this case is, it may be that the terms of the DDA weren't followed for whatever reason, but you knew that under the agreement that the closing was supposed to occur on that date. So you were on notice. We have a problem, and you might have forborne going forward, but you were at the point on notice. Houston, we have a problem here.
Well, Your Honor, I think the parties did recognize that there was an issue, and the parties did continue to work together to extend that time. Neither party treated that up until this case. Neither party treated that date as material because of the events of the Great Recession.
Which date? The 2008 date, the
April 2nd, 2008
date.
But
what about the March 11th date?
Right. That's
the
number
March
two.
15th date. And now March, I can see the point. Well, it came and went, but both parties are agreeing to waive it, and no one's really sort of drawing a line in the sand. But you get a letter on March 15th, 2011, that says it's over. And that seems to me to give sort of would give a party, gee, I better file a notice of claim. If I'm claiming this is a breach, I better file a notice of claim and file a lawsuit within a year, or I'm going to be in real trouble. If maybe we can work this out, maybe we can settle this, but if I don't, they've fired the warning shot and said this is over. And yet the lawsuit doesn't get filed until, the notice of default isn't sent until October 25th, 2013. And then the city files suit, and TFM files a counterclaim. Why isn't the counterclaim barred, given the March 15th letter?
The March 15, 2011 letter.
Yeah, let's deal with that.
That's because by reading the development agreement together with the statute, ARS 12-821C, the cause of action hadn't accrued because there was no mediation.
Okay, but doesn't... here's the problem I've got with that. I understand that argument. But it seems to me, with the final conclusion on that, if you take it to its logical conclusion, is that I've got a mediation clause in my contract. I don't have to do anything. I can sit around for a couple of years, maybe a decade, doesn't matter. I can wait as long as I want. I don't have to ask for mediation. If I've reached a dispute with the other side and we think there's a breach, I don't have to do anything, and my statute of limitations never tolls. Isn't that the logical conclusion of what that argument is?
Well, I had two responses, Your Honor. First is that the development agreement was broader than simply mediation. The development agreement provided that a party shall be free to initiate litigation upon the conclusion of mediation or 90 days after the date the parties first reached an impasse on the subject matter of the dispute, whichever occurs later. That's the last sentence in section 15.2. Mm-hmm. The evidence that we presented, Your Honor, is that the parties continued to talk about amending the development agreement to resolve this dispute right up until October 2013, right before the city said, okay, look, we're going to put this out for a request for qualifications for a new buyer, and then immediately afterwards filed the lawsuit. So there was no impasse between the 2011, and remember, the Great Recession is still a problem for every developer in the state of Arizona from 2011 to 2013.
But don't we have a lot of case law dealing with the municipal claims statute that says that you can talk about settlement all you want to, but once you know or should know that you have a cause of action and that they're claiming that in this case the contract's been terminated, you've got 1 year to do X, Y, and Z, right?
I don't believe any of those cases, Your Honor, dealt with the mediation provision of that statute, which said the cause of action doesn't accrue until after the ADR process is through, and the ADR process was never completed.
Do we have a case you can point me to that says that mediation forestalls any further activity under 12.82101?
I can point you to the statute, which is exactly what the statute says.
Well, there's certainly a statute that says mediation can occur and all that.
No, the statute says a cause of action does not accrue until an ADR process that's provided for an agreement is completed, before that process is completed. And that process was never completed because the parties still were negotiating an amendment to the development agreement to resolve this dispute. And the development agreement, which is where the mediation provision appeared, which sort of is incorporated into the statute, said not only must mediation occur in the alternative when the parties reach an impasse, whichever is later. And the impasse is what never occurred. That later provision is what never occurred.
So the statute really does toll as long as the parties never initiate the ADR proceedings. And how can that be?
Well, Your Honor, if I understand your question right, the city of Tempe was always free to request mediation. I mean, they say in their briefs, well, this would be a permanent tolling of the statute of limitations until one party decides to do something. They were always free to request mediation. They knew what the development agreement provision said. They knew what the statute said. They could have, on March 15th, 2011, they could have sent Tempe Flour Mill a letter that said, we are requesting mediation pursuant to the terms of the development agreement. We believe a dispute has arisen.
But in all honesty, I mean, it's Tempe Flour Mills that's seeking to take advantage of I don't mean this in a negative sense, but take advantage of subsection C of the statute saying that our cause of action is told, doesn't accrue until the end of mediation.
Well, I think it goes
So,
both ways. The city's cause of action, the city's taking the position that its cause of action
The
accrued.
city
And
just, right, but the city could just want a quiet title to the property.
Yes.
At that point, it just wanted to make sure it could go forward.
Right.
But let me see if I understand.
But even if the city of Tempe, even if Tempe Flour Mill is trying to take advantage of the statute,
Right.
The city still could have requested mediation. The city could have said, there's a dispute here because you guys are now saying that you get the property.
Their view is we don't have to do that. If I understand it, their view is we don't have to do that because the contract's over.
Right.
Now, that may be wrong, and that could be wrong, but the thing is, we don't have to ask for mediation because we think the contract's over.
Then
So
they-
if you disagree with that, then you ask for mediation.
Well, that never occurred. I mean, they certainly took
But
the
they
position.
don't have to ask that. They just said the contract's over. If you disagree with that, you can then decide, well, I better ask for mediation. Otherwise, I may be risking the fact that the statute of limitation has expired.
Well, again, the parties were trying to resolve their disputes, didn't reach an impasse, so that didn't get to a position where mediation was.
And that's what I want to get to.
And if the city believed there was an impasse, the city of Tempe could have said so.
Got it.
Tempe
So-
Flour Mill didn't believe there was an impasse.
So what you're saying is, I'm looking at 15.2. First sentence says, if there's a dispute hereunder the parties cannot resolve between themselves, then there's a 90-day moratorium on litigation, in which they'll try to go through mediation. So you're saying that up until October of 2013, the parties had been negotiating, trying to see if they could to resolve the dispute. Is that what you're saying?
Yes, and I think if you read that with the last sentence,
I was going to get to.
on 15.2, you beat that with the impasse language.
And
That's
Because
what
then
I'm
you're
saying.
saying you can start litigation upon the conclusion of mediation or 90 days after the parties first reached an impasse on the subject matter of the dispute, whichever occurs later. Well, since there wasn't any mediation, it would be 90 days after they reached an impasse. And you're saying that no impasse was reached because the parties were still negotiating until October of 2013. Is that right?
Correct.
When the city went out and said, we're going to rebid this.
Correct. And I can point you to some exhibits in the record that support our claim, and there's no contrary evidence, support our claim that up until October of 2013, the parties were still negotiating an amended
Are those,
development agreement.
those exhibits listed in your brief?
They probably are, but to make it a little easier, it's Exhibit K to the city's Statement of Facts, the initial Statement of Facts. That's dated November 19,
Do you have a
2014.
record number?
It's tough because of the way they break out the. I can't tell which part.
It's Exhibit K, the city's.
To the city's
Statement of
initial
Facts.
Statement of Facts.
Okay.
Where the parties are discussing terms of an amended development agreement.
Okay.
Exhibits D and E to the city's controversy statement of facts, which are answers to interrogatories, our answers to the city's interrogatories and requests for production, where we describe conversations occurring until 2013, and a list of meetings that Tempe Flour Mill representatives had with Mayor Hallman at the time. And Exhibit G to the amended complaint, oh, by the way, the city's controversy statement of facts, that's dated February 11, 2014, in lieu of a
right.
IRA
Exhibit
number.
G to what?
And then Exhibit G to the amended complaint, which is a notice of claim that was submitted by Tempe Flour Mill, which also says that there were discussions that were occurring through October 2013.
When was the notice of claim filed, by the way?
I don't know the date, but it was in October 2013.
Okay.
So I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel.
Good morning, Your Honors. Gary Birnbaum from the Dickinson Wright firm, accompanied by Mr. Charles Cahoy, Deputy City Attorney from the City of Tempe, appearing on behalf of the appellee, City of Tempe. Your Honor, thank you collectively for your very fine and pointed questions. So let me begin by just supplementing one thing that's already in your questions. It is absolutely true, as you pointed out, that Section 6.1b says, quote, "In no event shall close of escrow for the project property occur later than 18 months following the execution of the third agreement."
Who does that bind?
Excuse me, Your Honor?
Who does that bind?
That
What does
bind-
that provision do?
Binds both parties, Your Honor. It provides an expiration date for the agreement, and it means exactly what it says. And I'll get to this point, but Arizona law is crystal clear that when there's a provision that says an agreement expires on a certain date, then after that date, neither party has any obligations to perform under the agreement.
I believe counsel said in regard to my question that it was incumbent upon the town of Tempe, if they believed that was, and I'm sorry I did that twice, the city of Tempe, that it was incumbent upon the city then to assert that, because it was their duty to assert that if that was the case. I'm
Thank
a little
you.
bit lost on that.
Thank
so
you.
help me out.
Thank you for clarifying the question, Your Honor. Kemp, my good friend, Mr. Gross, is absolutely wrong. The agreement it's an expiration clause. It is self-effectuating. It is binding upon both parties. When the expiration date occurs, neither party has to do anything, but neither party has any rights any further under the agreement. And as Judge Kessler pointed out, it's not that the city didn't do anything. In fact, while not obligated to, the city sent, I think it's at least 4, but certainly 2 unequivocal, unambiguous written statements that said, "Be warned, the agreement has expired. You have no further rights under it. All rights are terminated." And that occurred in 2011 at the latest.
That's before the letter of March 15th or after?
The letter of March 15th, I believe, is in 2011.
Yes.
I believe that's one of the notices. I think in our brief we've outlined that there's at least 4. But the thing I wanted to supplement, Your Honor, as clear as 6.1b is, for some reason, the appellant, neither in the trial court, nor in its written argument here, nor in its oral argument, has ever referenced 6.1.10, another provision of the contract, we believe identical in effect and almost identical in wording. But it's very significant because in our answering brief, we quote it right up front and say, well, how do you respond to this one? So since there never has been a response, let me, with the court's permission, read one sentence out of 6.1.10. In no event, same phrase, in no event shall the close of escrow and the city's $7.1 million payment or credit against the project property purchase price occur later than 18 months after execution of this agreement. Now, I don't think there was any ambiguity in 6.1b, and I don't think Mr. Gross has been able to answer your very specific questions about that. But what about 6.1.10? This one, if you can be more specific, is even more specific. The close of escrow has to occur by that date, and the city's payment obligations under the agreement, disappear if the close of escrow has not occurred by that date. So we have 2 provisions. They are unambiguous. They have only one possible meaning, and they're dispositive of this case. Now, what happens after that is there are 8, at least as I count them, 8 separate excuses that are then offered in an effort to overcome the unambiguous expiration provision. So I will try to summarize those as quickly as I can. They are all addressed in our brief. The first one is they claim, well, they were surprised that the city raise the expiration argument. With all due respect, I don't believe their surprise is a defense, but if what they're suggesting is somehow or other it was hidden from them, that's just absolutely not true. There are at least 2 points in the city's summary judgment papers where the city explains the history and says, look, we've told you that the agreement expired. There's this body of exchanges that Judge Kessler pointed to, including the March 2011 letter, where they are told it's expired, you have no further rights. Then it's mentioned twice in the summary judgment motion. Then there's the oral argument in the trial court, which I presented, Your Honor, and that very much focuses, like this argument does, upon the expiration provisions. So we have over and over and over again a warning that this agreement has expired.
But counsel says you kept working with them. You kept talking to them.
Well, there's
You didn't act like it was at an end.
There's a series of responses to that, Your Honor, and I think Judge Kessler mentioned this as well. The city did keep talking. The city may continue to talk to the principals of Tempe Flour Mill today about possibilities in the future. None of those constitute a resuscitation of an expired agreement as a matter of law and also as a matter of fact, because nobody ever suggested, oh, we're waiving expiration. To the contrary, there are at least 2 written documents, one of which, Judge Jones, you've now referred to, where the city says, make no mistake about it, you're right, the agreement's expired, your rights are terminated, and we are not reinstating that agreement.
I'm sorry, Counsel. You say that was in a letter or an email?
Yes, Your Honor. And
Where is that in the record?
I will, as we continue, I will ask my colleague to get the page and the reference to the email. But in our answering brief, Your Honor, we did walk through each of the correspondence and each of the responses that were filed. And I'll get that for you in just a moment, if that's okay. Then there seems to be the suggestion that the phrase "in no event" is somehow or other ambiguous. It's not clear whether that's the appellant's argument, but I suspect the reason it's not clear is because Arizona law is. Most recently, our Supreme Court, in the case of Shea Holmes versus Albano, that's a case that involved the statute of repose, and the Supreme Court said the statute says in no event can you bring a claim after a specific date. And the court said that may or may not be good policy. Take it up with the legislature if you want to change it. There's no question that in no event means in no event. Historically, the leading case, Southern Pacific Co. versus Yuma, has the following pretty unambiguous quotation. Quote, "It could not very well be more specifically or plainly stated." Close quote. That's referring to the phrase in no event. All right, Judge Kessler, let's see.
These are the documents. Are you jumping to the business about while there were discussions going on?
Yes.
Business.
Yes.
My question about while the discussions were going on, was there a waiver of the expiration, or were you trying to say, even though we're talking, there's still no agreement, and we're not reinstating it? Is that found beginning at those documents beginning 12 or 13 of your answering brief?
There is some reference there. No, Your Honor, at pages 34 through 35, it's the bullet points. There is a list of each letter with the appropriate quotation, including the responses that came from the other side. Just to give you an example of some of them, the termination letter itself, using that phrase for the March letter, Judge Jones, says that the parties were relieved of any further obligations under the DDA. Termination letter goes on and says that it was a condition precedent that can no longer be satisfied. Later it says...
What about the October 13th? I don't mean to,
Sure.
I do mean to interrupt you, and I apologize for that. But October 20, this is a summary judgment. October 2013, the city and TFM had some communications about possible terms for reinstating the DDA. Doesn't that, at least as far as October 2013, seem to indicate that maybe there wasn't an impasse? And the reason I say this is summary judgment is we construe all the facts in the light most favorable to the party opposing summary judgment. Their argument was, until October 2013, there really wasn't an impasse. And that October 13th does seem to say, the city was saying, well, maybe we'll reinstate it. It's over. Understand it's over, but maybe we can reinstate it.
I completely disagree with that set of assumptions. First, I'm looking for your reference, Your Honor, at page 35 of the answering brief. Okay, there is a list. In October 2013, there were some communications about the possibility of reinstating the DDA. Well, first, you can't reinstate an agreement that is not expired.
I'm not debating that with you. I agree.
Second, Your Honor, it goes on in the motion in two places to specifically state, that's the next bullet, that the agreement has expired. And then, this may be of even more interest to you, the response refers to the fact that there was an 18-month conveyance of property deadline that has already passed.
I'm not making my question clear. I agree with you that each time the city said, hey, this is expired, this is over. My understanding of their argument is it may, they disagree with that. But even if it had expired, had they reached an impasse?
Well,
and the one question I've got, and this is the only question, is, now I'll look at the document, but in October 2013, you say in your brief, the city and TFM had some communications about possible terms for reinstating the DDA. That gets me a little uneasy about the idea of that there was an impasse.
Well, let me try to make you feel better, particularly about the word impasse. Okay, because I think you're being unintentionally, of course, misled.
Okay.
The word impasse that you're referring to is in section 15.12 of the agreement, which is the, quote, ADR provision. Right. Let me begin with this statement. Number one, the ADR provision has nothing to do with the case before you. If the agreement has expired by its terms, there is no breach, there is no termination, there is no dispute to be arbitrated. That's the point of expiration. It has expired. Second, I would point out to you, Your Honor, although I don't think you need to get anywhere near this far down the road, let me tell you that we don't believe section 15.12 says anything like what you're being asked to read. Let me tell you what we think it says. The first sentence unambiguously says, assuming we have a dispute, not an expiration, if there's a dispute, the parties will spend 90 days trying to mediate that dispute.
What triggers the 90 days, counsel?
Excuse me?
What triggers the 90 days?
Well, Your Honor, it doesn't specifically say, but there has to be at least either some dispute or some statement by one party or the other saying there's a dispute, we invoke the ADR provision.
Well, the reason I ask that is because a half a dozen times you've pointed out where you've said it's not capable of being reinstated, it is lapsed, it is gone, it is done.
I understand your question. The answer to that, Your Honor, is for purposes of limitations, all of those communications begin the limitations period, and any one of them can be viewed as beginning the 90 days, except nobody's claiming there's a breach. It doesn't apply at all. If it does, limitations is run. But allow me to finish the thought, because you haven't heard this. The first sentence of 1512 says the parties, whoever wants to, has 90 days if there's a dispute over a possible breach to initiate mediation. Now, it's interesting, Your Honor, that nowhere in the appellant's brief, nowhere in the argument, and nowhere today have they ever looked at the rest of the clause. Because what it says in the first sentence is you have 90 days. The entire balance of the provision is all about, now if somebody invokes mediation, then here's how it's going to be handled. It then goes on to say, here's how we're going to pick the mediator, here's how we're going to have a hearing, and I won't bore you by going through the details. It explains all of the process of the mediating until such time as you either resolve the case or you reach an impasse. The last sentence doesn't limit or change the first sentence. The last sentence is about what happens if you have mediated and you reach an impasse.
No, counsel, I disagree with you. Maybe I'm wrong. The way I read it, it says, either the results of the mediation shall be non-binding, and any party shall be free to initiate litigation upon the conclusion of mediation or 90 days after the date the parties first reached an impasse on the subject matter dispute, whichever occurs later. That or seems to me to mean either, whichever comes later, either one, after the conclusion of the mediation, or where you've reached an impasse.
Yeah, but it's reaching, again, Your Honor, I'm sorry to go down this path because we don't think you need to get anywhere near this. But that clause in context is talking about you either mediate to conclusion or you mediate to an impasse. It's all about the mediation process. The first sentence says there's going to be a stay of all proceedings for 90 days. And you're going to go mediate during those 90 days. You're going to finish the mediation. You're either going to succeed or you're going to reach impasse and fail. And then you may proceed with litigation after the 90 days.
Why does it have a whichever occurs later? It says on the conclusion of mediation or 90 days after the parties first reached an impasse.
Because, Your Honor,
whichever occurs later.
Because if you go to mediation, as you well know, you can have a successful termination or an unsuccessful termination 1 day, 2 days, 3 days, or 5 days into the mediation.
Right.
Or 89 days later, the mediator may say, boy, we've all done a good job, but the parties have reached an impasse. There will be no settlement. I declare an impasse has been reached. But Your Honor, let me go back just so I don't get lost in the argument and say to you, this all is buying into the notion that an expiration is not an expiration.
Okay.
And Arizona law, and we certainly agree, says it's not even an ambiguous provision. It expires.
I understand that, but if there's a dispute about, I mean, the mediation clause does talk about a dispute. Can't you have a dispute about whether this is an expiration?
Well, if you could, and I'm trying to go down your path again, if you could, then in 2011, when you get a notice that says the agreement is expired, your rights are done, at that point, one, limitation starts to accrue, and two, if they want to assert a breach of some kind, then they need to come forward and do that. And whether you call it waiver or estoppel or latches, you can't have this notice that your agreement expired in 2008. You can't get an unambiguous notice repeated in 2011 and then come forward in 2013, 14, or 15 and say, my claims are still alive, limitations does not bar me, and I have not waived the right to now go pursue a claim. You can't do that.
So if I understand you, I just want to make sure we're on the same track.
Yes.
Is that once Flour Mills gets its March letter saying, okay, this is over, it's expired. If they dispute that, they should either, their claim is accrued, or at a minimum, they should have asked for mediation.
I agree with all of that, except that you have, in my view, left out the first sentence, which is nobody had to do anything. The agreement expired.
But if they want, right.
The city then sent them a confirmation that it expired.
Right.
If they wanted to take some action at that time, they were free to do so.
Right.
If not, it has at least been waived or barred by the passage of time.
Counsel,
Thank
so
you.
I understand.
Yes, Your Honor.
The way I understand opposing counsel's argument is that you sent all those notices out. You told him it's done. This thing is terminated,
Yes,
right?
Your Honor.
Okay. Is it fair to say that their position is that since there was this mediation provision, that no matter what you sent out, no matter if it was 20 or 30 years and someone found this in an old desk drawer somewhere, it would not be an expired agreement until mediation had been had?
Your Honor, thank you for giving me the chance to interpret their case. That's the way we understand they are arguing. And the problem with it, besides being impractical and almost a bit foolhardy, is it doesn't answer the first question, which is 6.1b and 6.1.10. Both say the agreement expired. And as the court itself has already pointed out, if we sent a notice that we didn't have to send, and that notice says we're telling you it expired, we're telling you there are no rights left, we're telling you your rights are terminated, it's hard to see how that could constitute a reinstatement of the expired agreement. I hope that answers your questions, Your Honor. And thank you for the extra time to do that.
No.
Thank you.
Thank you very much.
Counsel, before you get going, let me make sure I looked at one of the reasons I looked down while you were talking is because we're now in electronic court. And if I want to look at the briefs while we're listening to your argument, I'm doing that. So I'm not ignoring you. I'm actually trying to listen to you while I'm looking at your brief. And I looked at the pages of your brief about the statute of limitations, your opening brief. And I had a hard time finding an argument that because the city was negotiating with us up until October 2013, there wasn't an impasse. I mean, you clearly talk about the mediation provision. I mean, there's no question about that and about the statute of limitations. But I couldn't find an argument that said, listen, the reason that the statute of limitations, the cause of action hadn't accrued was because the city and we were still negotiating up to October 2013 about reinstating or at least trying to resolve our differences. And maybe I just missed it.
Your Honor, I thought it was in here. I think it's implicit in what we were arguing in the sections that we quote in the development agreement about the city not taking any action to invoke the mediation provision, and the discussion about the recession and the parties' cooperation in not declaring each other in default. Because of trying to weather out the storm of the Great Recession.
Is this a party declaring default, or is it just a recognition that the agreement has expired?
I'm sorry, I don't understand the question, Your Honor.
Is it a default? I had the same question when I heard you say that. Do we have to strictly define this as a default? Or is it simply a fact that the contract is no longer enforced?
Well, I think that goes back to the argument on the merits and whether the contract has expired by its terms or not, and what Section 6.1.b means. And again, I think Mr. Birnbaum's wrong. We don't say that in no event is ambiguous, but to the extent there's any ambiguity, and why we believe it's reasonably susceptible to our interpretation and Taylor should apply, is that the notwithstanding the foregoing language says, in the second sentence, says no matter what happens with respect to the building permit, the transaction is going to close, must close within 18 months of execution. That's consistent with what the city, how the city interpreted it through its actions. It's consistent with the context of how the agreement arose in the first place, and MCW's interest in not having an open-ended and allowing the city to continue to delay and having some sort of certainty about when they were going to get the property.
Well, I'm having difficulty understanding that the city believes that the agreement expired, and I understand that you don't believe so. But once they sent you a letter saying it's expired, isn't it incumbent upon you to do something about that?
We did. We went back to the city and said, we're going to try to make this right. We want to resolve this, and until there's an impasse, our cause of action doesn't accrue. And maybe we're not, our position is not that the agreement can get stuck in a drawer for 20 or 30 years, and then we have a right to say, well, we get the property because nothing happened. At some point, there's going to be an implied waiver. But it didn't happen under the facts of this case, or at least it didn't happen as a matter of law under the facts of this case. There are lots of facts that are in dispute as to what happened, who was talking to who, what was being said, and the impact of that on the mediation provision in the development agreement, and as a result, the statute that clearly provides that cause of action does not accrue until an ADR process in an agreement has finalized.
So once you received the letter, then you began the mediation process?
I'm sorry?
So once you received that letter that said the agreement has expired, did you invoke this solution and begin the mediation process?
Well, we took issue with the city's position that it had expired. And then the city never invoked the mediation provision.
Well, but it seems it would be incumbent upon you to do that at that point.
Well, I think at that point we have an option. One is go back to the city and try to say, we have an obligation here to try to work this out. Let's go until we get an impasse, or somebody's going to have to request mediation at some point.
Things would have been a lot easier if you just did that.
Well, maybe it might have been easier looking back in hindsight, but Tempe Flour Mill at the time thought it could be worked out. There was no reason to request mediation. There was no reason to file a notice of claim. I mean, the public policy for having a mediation provision in the statute in the first place is we don't want property owners or private individuals to have to serially file notices of a claim with the city while they're still under discussion about trying to resolve a potential claim. We want there to be certainty at the end of the day as to when the mediation or there's an impasse or cause of action accrues. It doesn't serve anybody to have notice of claims served every time a conversation or a discussion to resolve a dispute lulls.
Of course, you could also, I mean, it is hindsight. You could also say, we think there's a dispute here, we'd like to resolve it, and we don't want to file a notice of claim. Would you agree to waive the notice of claim provision while we're trying to resolve this?
That's an option. I don't think that there's anybody.
And I'm not faulting you for not doing that. I'm not criticizing you in any way. But that's an option that parties have, too, of trying to resolve these things.
Counsel, you just got the longest 2 minutes and 22 seconds of rebuttal that I think we've ever had here.
Well, I appreciate the opportunity. Thank you.
Well, thank you for your argument. Thank you for hanging with us as we're wanting to make sure we have the facts of the case squared away. We're going to take this under advisement at this time. Thank you very much for your argument. We do appreciate it. We are going to stay in place here and allow the next case to come forward. So if we could please have the folks with the, I believe it's Quam versus Grove matter come forward, we would appreciate it. You do okay? Thank you. Okay, thank you.